Very much, Javier. It is a very interesting topic. It brings light to all the Latin American lawyers. So we now proceed with Victor Maskin, and he's going to talk about some jurisdictional issues. Go ahead, Victor.
Thank you, Karla. First, just let me say it is a true pleasure and as well as an honor to be appearing before the U.S.-Mexican Bar Association, accompanied by this very distinguished panel, physically located in different parts of the world. I want to continue really from where Javier left off, where Mark and Javier left off. Mark gave us a comprehensive description of what it is that's discoverable and how you do it. And Javier gave us a comprehensive description of what 28 U.S. Code 1782 is and how it works. He also spoke to some extent about who may be the possible targets of discovery, from whom can discovery be obtained. So there are two categories. There are individuals and there are entities. With individuals, it's really quite easy. You find the individual and then you start your proceeding in the place where that individual happens to be located or found, as the statute itself says. With entities, it gets much more complicated. And some of the reasons for this go back a number of years in the U.S., the jurisprudence of U.S. discovery. So I'm going to give you a little bit of a history lesson on how this evolved, where we started some years back, and how we got to where we are now. If you go back to 1945, there was a very famous case in the U.S. Supreme Court called International Shoe. And U.S. lawyers, we all learn about this case in the first year of law school. And what it involved was, just briefly on the facts, a Missouri corporation was doing business in the state of Washington. The state of Washington imposed a tax on the Missouri corporation, and they said, no, you can't do that because we're a Missouri corporation. We're incorporated, it's where our business is. So we sell some shoes here, but that's not enough. But the Supreme Court came around to disagreeing on that, because they did have a business activity there. And they came up with some language that was repeated year after year in many cases, what they called a continuous and systematic course of doing business subjected the company to doing the jurisdiction within that state. The only limitation was what they called fair play and substantial justice. A sufficiently vague term that can be interpreted in many different ways, but what did it lead to? It led to a jurisdictional principle that over the years came to be called general jurisdiction. And what that meant was that if a company has any kind of a substantial and continuous and systematic presence in a state or a judicial district, it can be sued virtually over anything. So it meant that the subject matter of a case could be completely unrelated to the forum where the case is being brought. And as commerce...
Victor, a question about that. Do you mean to say, for example, that if a Mexican company operates in the US, a US court could take jurisdiction over it for completely unrelated thing it did, like in Brazil?
You know, Karla, that's exactly the right question. And it's exactly the right question because there are two answers. And the first answer would be the correct answer. The answer would be yes up to 2014. And after 2014, the answer would be no. So that leads me to the next piece of history that I want to discuss here. And it is a case that was brought in California against the Daimler-Benz, Mercedes-Benz car company in Germany. And the facts of this case illustrate why there was such a change in the law. But just to talk a little bit more about what this case was about, it related, believe it or not, to the well-known facts of the dirty war in Argentina in the 1970s. Now,
and what can the dirty war possibly have had to do with discovery under Section 1782?
That is exactly the question that gave the late, great Justice Ruth Bader Ginsburg a great deal of trouble at the Supreme Court. What we had going on there was that Mercedes-Benz Argentina, the subsidiary there, was alleged to have participated in these nefarious activities. The plaintiffs wanted to sue them for damages, but unfortunately the head office was in Stuttgart in Germany. The plaintiffs went to California, where another sub called MB, Mercedes-Benz USA, had something like $2 billion worth of business. Clearly, they are found there, if you will, under 1782 because of that big business presence. And they allege that the USA sub and the Argentinian subsidiary were all part of the same company, Daimler-Benz of Germany. So they sued Daimler in California. Unfortunately for them, their case wound up first dismissed at the district court level, then it was sustained at the Ninth Circuit Court of Appeals, so you can see how close an issue this was. But when it got before the U.S. Supreme Court decided this is a jurisdictional reach that is going just too far. They reversed and they dismissed the case, and it was a unanimous dismissal. 7 justices agreed with Justice Ginsburg. There was a concurring opinion by Justice Sotomayor on a somewhat related grounds, but it was a unanimous dismissal that this went too far. So as a result of the Daimler case in the Supreme Court, now there's a new rule, at least since 2014. The new rule is that this general jurisdiction theory under which, yes, a Mexican company operating in Brazil could have been reached in Texas, that no longer applies. And as Javier was explaining in his presentation, the corporation that you're going after can be sued only in the jurisdiction where it's incorporated or the jurisdiction where it has its main office. And if this is not a United States corporation, but it's having activities in the United States, you wind up getting into significantly more difficult problems in going after them under 1782. And this relates to 1782 because the 1782 discovery jurisdiction generally follows the court's jurisdiction to entertain a case, a plenary case against that same defendant. So bottom line for Mexico on this, if you have a case in Mexico, no longer do you have general 1782 jurisdiction against this U.S. target wherever you can find it in the U.S. You have to go to its home jurisdiction, wherever that is, and unless, and that's the main caveat, the discovery relates to something that this company did in the state or the district, the federal district where you have found it. That leads me to a case that Jeffrey and I have collaborated on. It's actually still ongoing to some extent, that we had brought in New York against Deutsche Bank, the German bank. And if you think about this, you have the 17th largest bank in the world. You have $1.5 trillion in assets. It's got 90,000 employees, 10% of whom were in the US and over 1,000 of whom were in New York. They had a major lease on Wall Street where they occupied over 1 million square feet. They paid huge rent. They had billions in assets in New York. It was their main US office by far, but they claimed that they were invisible to the court under 1782 because their home office was Germany, because all of the information we wanted had originated from instructions in Germany. And what were we to do? Well, you know, the answer that we managed to put before the court was that, in fact, they were, although giving instructions in Germany for trading activity, That trading took place in New York on a New York exchange. And because the information was in New York, the Southern District of New York Court sustained jurisdiction there. So my colleague Jeffrey is going to speak further about how in Mexico you can structure your U.S. discovery requests to satisfy these more limited jurisdictional requirements and the requirements of Section 1782, along with the many other very useful practice tips that he will convey to you. So unless there are any other questions, I will yield the floor to Jeffrey Morrison, across the ocean in Cambridge, England.
Thank you very much, Victor. And go ahead, Jeffrey. You already been introduced and your topic also.
Thank you. There was a note I got that my camera was off. Is it on again? Everything's fine? Well, thank you, Victor, for the warm and friendly introduction. Victor and I have known each other for about 20 years, so it's been a very good friendship, but also a very good professional relationship, because being an American lawyer in Europe, there's plenty to do, but you still need to work with someone local who is knowledgeable and creative, but who also understands the international aspects of things. And that essentially is the focus of my brief points that I will mention right now. And I try to supplement them in the written materials. And I've given some case examples, two of which relate to Mexico and one which relates to the Panama Canal. There's actually a lot of 1782 material relating to South America, Colombia, Ecuador in particular. But as happens in our profession, cases that are helpful and instructive happen only when people are willing to litigate them. And so the rest has to be filled in by good sense and by advocacy. So what I'm going to go through now is a very brief list of some of the points which I think meet my topic, which is how should U.S. and Mexican counsel best collaborate regarding the implementation of a successful and cost-effective 1782 strategy. So here we go. U.S. and Mexican counsel should jointly make sure that the Mexican legal proceedings are before a tribunal, which does satisfy the definition of tribunal under Section 1782. A traditional court will usually do so, as has been stated, as may a tax audit board court or a bankruptcy court or an employment court, but non-adjudicated proceedings before an administrative agency or quasi-judicial body may not meet the bar, or they may meet the bar. The tribunal can be the highest Mexican appellate court down to the lowest court at state level, including a local traffic court. It can also be a criminal court. And a 1782 petition can be filed on the basis that there are Mexican criminal investigations being conducted, even though there is not yet a formal accusation or indictment. A Mexican recurso de amparo proceeding in the Rivada litigation, which I cite in my materials, seems to have been sufficient basis for the tribunal test. But does this type of internal Mexican constitutional judicial review really involve the kind of tribunal contemplated in Intel, the case which was cited before? The point is unresolved as to the recurso de amparo. See Articles 103 and 107 of the Mexican Constitution, and again, the cases cited in the program materials. Arbitration panels, as stated, may or may not meet the tribunal test, depending upon the type of arbitration panel and depending upon the specific U.S. district court in which the 1782 petition is filed. We may get a little more information about this from the Ninth Circuit, because there is a case pending right now in which a brief was just filed a couple of days ago, and there may be some further enlightenment on this. However, a foreign court proceeding to enforce an arbitration award should qualify for 1782 discovery if the court itself qualifies as a tribunal. Great care should be exercised to avoid the risk of procedural dismissal of the Mexican legal proceedings. for instance, on the basis of expiration of the statute of limitations. Pending Mexican litigation at any stage of progression is sufficient for 1782 purposes and includes appeals. If the Mexican case is dismissed for any reason, but without the possibility of appeal or refiling, the basis for 1782 will fail. The U.S. court usually does not care about the nature or the merits of the underlying Mexican dispute. Antitrust, crime, breach of contract, individual or mass tort, divorce, bankruptcy, patents, copyright, trademarks, class actions, post-judgment asset tracing and attachment of assets, all those should suffice unless, unusually, there is a compelling argument that U.S. national security issues are at stake and the U.S. government is the target of discovery. For example, in the Princess Diana case in 2000, Section 1782 was unsuccessfully sought to be used by a private litigant against the U.S. Central Intelligence Agency. But U.S. case law suggests that a foreign government should be able to invoke 1782 in order to obtain discovery in the USA. Thus, in Re Ecuador, a federal district court judge in California held that sovereign states are interested persons and have legal standing, and thus can use 1782 to obtain discovery, and that under some circumstances a foreign prosecutor as an individual is also such an interested person with legal standing. Now there, the experienced Mexican and U.S. counsel will also look at mutual legal assistance treaty and Hague Convention and other avenues, but this focus is only about 1782. Moreover, procedural joinder of interested parties in the 1782 petition is available in a wider context than joinder of litigants in Mexican legal proceedings. U.S. and Mexican counsel should jointly consider a strategy of mix and match on the Mexican side of the legal proceedings, civil and criminal, court litigation and private arbitration, court litigation and treaty arbitration, trial court and appeal court, and to mix and match on the U.S. side, different petitioners, different respondents, different U.S. district courts, and different Mexican and other non-U.S. legal proceedings before different non-U.S. tribunals. The successful 1782 Revada petition in New York involved an actual pending recurso de amparo plus merely contemplated civil or other judicial proceedings in Mexico. And it worked. Whether one would have worked alone, we don't know. U.S. and Mexican counsel should jointly make sure that the Mexican pleadings can be broadly explained to the U.S. district judge in such a way to the extent necessary and sufficient so as to meet the required intel factors, while also being mindful that pleading additional detail about the Mexican case is not necessary and may be counterproductive, for instance, if disputes arising the scope for use issues that were mentioned. U.S. and Mexican counsel should also jointly take great care in selecting the right U.S. district court. This is not as straightforward as it may sound, thanks to the U.S. Supreme Court decision in Daimler, mentioned by Victor, which curiously enough was also a decision authored by the late Justice Ginsburg. And if you select the wrong U.S. district court, it may become too late to switch to the right one. Please see the cases cited in the program materials. In Revada, the petitioner went to 3 U.S. district courts in South Carolina and Virginia and New York with varying success and needless extra cost. Dueling affidavits of foreign law and of competing experts do happen in 1782 situations, but if the petition is properly supported in the first place, the respondents often do not even mount any counter affidavits. U.S. and Mexican counsel for petitioner may be to issue a knockout blow from the beginning. Anecdotally, in our Deutsche Bank case, Victor and I not only introduced to the Southern District of New York a very carefully written a declaration of German counsel, but we also attached and included a 30-page, very detailed expert opinion by a German expert on the trading subject matters relating to silver derivatives. Deutsche Bank offered nothing in opposition, which was good. But that took strategy, and it took a lot of extra work. Next, U.S. and Mexican counsel for petitioner need to work closely together in formulating the specific items to be discovered pursuant to 1782, namely the list of the arsenal of weapons that Mark outlined, namely the oral deposition testimony, documents, written interrogatories, and admissions to be sought. This part of the collaboration between U.S. and Mexican counsel is often the key to a successful 1782 petition, which means that U.S. counsel needs to understand the underlying Mexican legal proceedings as well and as deeply as Mexican counsel needs to understand the scope of judicial discretion which a U.S. federal judge may exercise or decline to exercise pursuant to Section 1782. In appropriate cases, U.S. and Mexican counsel for petitioners should consider the involvement of friendly interveners and supporting amicus briefs and be ready to defend against unfriendly interveners and adverse amicus briefs. A point about Intel that is often not mentioned is that after the Supreme Court case, the famous one in 2004, the Intel and Advanced Micro Devices dispute continued. Wasn't over. And decisively, the final outcome came because of the impact of an amicus brief. U.S. and Mexican counsel for petitioners should also pay particular attention when seeking discovery in parent subsidiary situations, as mentioned, and should devise appropriate alternative strategies, especially where the discovery is being sought from the U.S.-based subsidiary company for use against a non-U.S.-based parent company. And here it might be worthwhile just to mention that California does have a very special discovery statute called, briefly called the Foreign Subpoena Statute, or the International Discovery Act, which is often very useful. It's not quite like 1782, but it does not involve the Hague Convention, and it can be very useful for California targeted discovery and can be used together with 1782. Also beware of waiver and other avoidable errors. Please see some case examples cited in the program materials where they essentially lost the advantages that they had with otherwise well-prepared paperwork. And be prepared to go back for more than one bite of the 1782 petition apple, including amendments, joinder, and additional petitions where needed or desirable. And be prepared to negotiate with the respondents. Compromise may be better than to risk the U.S. judge exercising discretion against you, such as if the U.S. judge deems the petition to be seeking too much or to be without good cause or not in good faith. A compromise approved by the U.S. federal judge becomes a binding court order. Key point, U.S. and Mexican counsel must collaborate closely and cost effectively at all stages. This collaboration can be officially commemorated due to the fact that U.S. district courts will permit Mexican counsel to be identified in the 17 petition as of counsel, which is what was done in our Deutsche Bank case. Our German colleague is clearly identified on the pleadings as of counsel, and he deserves to be because he has played a significant role at all stages of the proceedings, which Victor and I are proud to say led to success. Thank you.
Thank you very much, Geoffrey. I have some questions for you. What is the most common reason for 1782 petition to be rejected or released or delayed?
I happen to have that answer at my fingertips. In my experience, it has been the most common reason for a petition to be rejected or delayed. And this is also borne out by the extensive case law all over the country. is when evidence is sought which is deemed to be excessive in scope or intrusiveness, or whose intended use in the foreign legal proceedings is not clearly and carefully explained, and using supporting declarations of non-U.S. counsel which do not properly address the intel factors. So it's the reverse order of the collaboration that needs to be done. And a point there that should be made, because we're talking here about errors, those of us on this panel are not always going to be on the petitioner end of a 1782 petition. All of these concepts apply the other way around, including for interveners, and many 1782 targets are not parties. That is true in our Deutsche Bank case. We have 3 respondents, Deutsche Bank and 2 other entities. The other entities, one is a German bank, and the other one is the the mercantile trading exchange in New York and Chicago. So they are third parties. And in each case, they have been represented by counsel, and their counsel has been very cooperative. They're not the main target. It's Deutsche Bank. So you don't have to fight with everybody.
Okay, thank you. And the other one is, what's the average time between filing a 1782 petition and receiving the discovery order? And also, if you have a limit of time to discover all this evidence and depositions and everything, does the court give you a time, like you have 3 months to discover, or it can be take a lot of time until you get all what you want?
Well, 2 questions. The average time, in my experience, is between 1 and 5 weeks. Although in our Deutsche Bank case, because at the time of the petition, we had a trial in Germany then imminent, we got the order in 1 day. The judge signed it the day afterwards. There have been subsequent postponements of the trial, but and the 1 to 5 weeks is borne out by my study of the 1782 jurisprudence all over the country. The second issue is yes and no. Federal judges are busy people. They have heavy-duty calendars. They do not want you to be running back and forth and turning them into a discovery magistrate. So they will give an order, and they will not give a discovery cutoff date, usually, which means that counsel are expected to cooperate and comply with the discovery order within a reasonable period of time. If there were some reason for a cutoff date, it would be enough so that the discovery could be conducted given its scope and complexity. I haven't encountered that in any case where the judge, although I could anticipate, if that happens, I think it's a sign you're not doing a good job. The judge is saying, basta, you know.
Okay, well, thank you, Geoffrey. Also, it was very important to have these practical considerations for both sides counsels. So, Jorge, I don't know if you want to ask questions.
I have 2 more questions. We are running out of time, but I have 2 quick questions for Mark and Javier, and if you can take no more than 2 minutes to answer. Mark, talking about of cost and fees, many of our colleagues in Mexico used to ask us about how much this costs. I know this is hard to predict, but the question is, it is possible to recover the expenses and the fees if we use 1782? And the second question, and this is for Javier, is about the jurisdiction. Normally we have cases in which it's clear that the assets or the company is in California, for instance, but we have others in which the potential defendant have economic interests either in California, Arizona, Florida, Texas. So can we choose in which of those jurisdictions file the petition? So there are 2 different questions. So Mark and Javier, please.
Sure. So I'll start with the fees. You can infer from what Geoffrey was talking about that this can get drawn out, can be simple, can be relatively quick, and you can hit a home run without a great deal of expense, or it can be very expensive when you get 30-page declaration from an expert, and then you get a German law expert and you file the motion and Deutsche Bank opposes it. So it can cost quite a bit of money. We have the American rule, which is each side pays its own legal fees, whether you win or lose. So generally speaking, you're going to be out of pocket for this under American law. Your American judge is not going to give you the money that you spent chasing this discovery. There are some exceptions if you happen to be within some statutory scheme that says, for example, maybe it's a consumer product case and there might be a statute that says you can recover. You have to hunt for those. They're rare. You may also be able to recover your fees if you have a contract that says the prevailing party recovers its fees, but then you haven't prevailed on the motion. You have to prevail in the case and then perhaps come back to your American judge. You may be able to recover your fees if you wind up incurring fees because there's sanctions, or the other side gets sanctioned rather. So your first motion to go in and get the discovery, probably not. You're going to spend that money. If they fail to comply with the order and you go back and you incur fees for that, you might get awarded those fees. And then with all that said, I don't know what would happen in Mexico, and perhaps Jeffrey or Victor or Javier does. So it may be that you incur $100 in the United States to chase this motion, and you cannot recover that money in the United States, but perhaps you could recover it in your Mexican proceeding as the prevailing party down there. And I don't know the answer to that.
Okay. Javier?
So Jorge, on the jurisdictional question, I think it's a good question. I think that you have to first determine which form of jurisdiction you are choosing, you're going after. So if the respondent from whom you are seeking discovery has their place of incorporation or their principal place of business in a particular district, that is the district where you would need to file the petition. And if the respondent is subject to general jurisdiction in that district, the fact that the documents may be located somewhere else would not be a problem. So I think clearly, if you have the ability to exercise or you have a district where you can get general jurisdiction over the respondent, that is clearly the best way forward. If, on the other hand, the respondent does not have their principal place of business or place of incorporation in the United States, then you are going to have to proceed under what's called specific jurisdiction. And Victor talked about that. Specific jurisdiction is harder to establish, and that is going to be a function of where the respondent can be found. And there is a lot of debate still about what does it mean for a corporation to be found in a particular district. And this was addressed by the Second Circuit Court of Appeals last year in a case that we were involved in on behalf of Mexican clients. And what the court came up with was a somewhat confusing standard, but essentially what it means is that if the respondent engages in activities with a particular district and the documents you are seeking relate to those activities within the district, then you would be able to get jurisdiction on specific jurisdiction grounds. And so really the answer to your question is you don't have freedom to choose where to go. It's really going to come down to where the respondent has their place of incorporation and principal place of business. And if they don't have that in the US, where did they engage in activities within the district such that you can establish that they are found in that district?
Thank you very much. Well, we are run out of time now. I just want to thank to all you for your time and for your terrific presentation. For the attendees, we want to let you know that we have written materials. Each one of our speakers send that materials, and we are posting them in our website. And so you will have access to the materials and to the contact information of each one of the panelists if you want to ask something directly to them. So thank you very much for your time. And do not miss the other conference of the U.S. Mexico Bar Association that are going to be very interesting. Thank you very much.